Well, thanks, Samson, and thanks to your listeners. You know, you just tried to put the finance minister's statement in full.
Once again, we are grateful that you made time. You haven't been on TV or radio for
in a long
decade
time.
or more.
I had to, because you sit back, you listen to the conversations, and you see the usual Ghanaian drama at play, where talk is cheap, where people make assumptions and presumptions. But because we live in a sensitive environment, to wit a democracy, occasionally we stampede decision makers, we stampede situations, and we always end up with failed outcomes. So you see that you have just reread the finance minister's statement, and if we listen to it and want to be candid, some of us will have to recall the statements we have made, because we have attributed to him a statement that he didn't make, an inference, an import that you cannot reasonably draw from his statement. Because one, we don't take our time to listen. Number two, we don't process. We always have desired objectives and we are quick to jump there. The man is saying, this money cannot go down the drain. If it has to go down the drain, I have to show that it is somebody's fault and that it has to be proven up front. People have already concluded that some people are thieves, some people have raided, some people have shared and are jumping around and saying throw them into jail. We have not learned how many times we have stampeded the system into these rushed conclusions, and when these situations are measured against the rigorous test of the law, they implode. The system suffers, we get nowhere, but we are back at it again. But I'm consoled, not just by a more critical evaluation of what the finance minister said, but when you lace it into what the Minister for Information said. The Minister for Information said, you know, the objective of government, and that is a consolation, is to ensure that we have a robust, well-regulated, and efficient banking system. And I think that's the bigger issue that we have to focus on. Then the minister says that criminality, the lesser objective, will also be addressed. I pray that those seized with the odious duty of making the decisions stay on this well set out objective and not be stampeded into the rushes, the rash conclusions, the prejudgments that people have already come to. Because if we do, again, we are not going to fix the problem. Now, Samson, first of all, banking generally, particularly in our part of the world.
Did you say criminality or prosecution should be a lesser objective?
He said that criminality is the lesser objective. That's what the minister says.
And you support that posture?
I support that. The reason I support that is that you can end up, if you want, assuming it could be done. And trust me, it won't happen in the way that people presume. We've lived this process time without number. But assuming it could be done, you don't solve this problem by throwing a few people into jail unless you go back and fix the fundamental problems. If you ask me, this is a huge, massive, and Bright got to it. It's a regulatory failure.
And can't we do both?
That is what
can't
it is.
Can't we do both?
We can do both.
Throwing those people in jail and fixing?
Absolutely. If people are responsible, ultimately they ought to be held responsible. But we need to do first things first. Why do I say so? Banking in our part of the world is the single most regulated activity. There's no activity as rigorously regulated, at least in terms of the formulation of the law, practice, and powers, like banking. Something, when you read this law, the Banks and Specialized Deposit Institutions Act, you will be scared as a lawyer at how much power that central bank has. They have more power than Jubilee House and the presidency.
Banking,
Powers that border on clear arbitrariness. It's a dangerous document. Now, and for anybody, and so as a result, in fact, when I read this in the UT crisis, and to be candid with your listeners, we have arbitration proceedings pending, instituted by my firm on behalf of some of the shareholders of UT Bank against the central bank. Because I said, you know what? We are giving to sitting by and waiting till we are banned. I think that people have to start testing this law in order to begin to get the law interpreted and circumscribed and defined. Otherwise, Samson, read this law, and anybody can go and look for this, is as much English. Now, and to have a regulator presiding over institutions with all of these powers, and we end up where we are. If you take a step back and pause, if indeed when the dust settles and the investigations are followed through, we find that these matters out there, all of these reports you are reading, they are allegations. Some are even untested, unfounded allegations. You will be, as the caveat is in the KPMG report, this is their opinion. They haven't even spoken to the people who are in charge. They have not verified the books. You cite a provision, 1445. There's no 1445. 1145. Now, you take the boldest report, which is supposed to have stoked this whole matter, particularly in relation to the
UTN Capital.
There are shareholders in, say, Capital Bank who don't know Boulders, have never spoken to Boulders, Boulders have never spoken to them. And yet, there is in their report the things stoking the emotions that shareholders have distributed as much as over $400 million Ghana cedis to themselves as shareholder loans. As I'm giving to doing, I found out and spoke to a shareholder. The shareholder said, listen, Mr. Kulendi, read my lips. I have never in my life borrowed one Ghana cedi from the bank. Never. I said, but Boulders say you have borrowed 11 million Ghana cedis and secured it with your shares.
So how does he explain that?
It's nomenclature. The bank is looking for new money, new injection and capital. On the books of the bank are bad debts. Bad debts. So everyone will do a preliminary due diligence and say, no, I can't touch this. It doesn't look attractive. In consultation and collaboration with the regulators, a decision was reached. Listen, if you stay with these kinds of debts on your books, nobody will put new money into your bank. And so you are headed to the brink. So why don't you, the shareholders, agree to absorb these debts, which is money you have the bank lent to people that you can't recover. And Samson, I'm in the business of recovering money for banks. As I speak to you, I have suits, huge suits, numbers. Ghanaians are given to borrowing and not paying. And so the banks are struggling with bad debts. People complain about interest rates. It's because our risk profile is bad. So these are real debts. So they say, apportion it to yourselves, absorb it as shareholders' loans, because at the end of the day, you are the stakeholders in the undertaking. It cleans up the books. To make it look better, collateralize the loans with your shares. So the loans are distributed pro rata. So this poor shareholder who I spoke to has 11 million charged to his name as a shareholder debt. He agreed to collateralize his shares in order to make the books look good and to attract new money. So that when new money comes in, efficiency is created, business booms, you get dividends, you eventually pay off that loan, which is money that some debtor didn't pay, and still make profit.
But is that a secure prospect that a new money will come in, you will get dividends, and then you end up paying off the loan? You have not taken a dime as a loan, and you agree that such a quantum, 11 million, should be posted against your name and against your shares.
Something that's
hoping that a new money will come in.
Yes.
And then when you make money, you get dividends, you pay off. Is that a secured, prospect?
So Samson, that is what distinguishes businessmen from the rest of us. When you set up law firm, you didn't know there was no security that you get a client. But you borrowed, invested money, borrowed to buy books, and set up the law firm. Okay? I did the same. I had no guarantee that somebody will trust me and give me their work. Businessmen are risk takers. But that's another conversation. But I'm saying, if this explanation is true, what is this business about shareholders' loans? So if Boulders had spoken to this shareholder, they would have had the benefit of this explanation. And so this misleading information that has stoked people to go around shouting and calling for people's heads, even before everyone is spoken to, these things are measured and evaluated, is all over.
Okay.
So if this is true, Samson, you are a lawyer. Bright, you are a lawyer. This is where you're going to go to court and say...
Bright is not, but his appreciation of the law is great.
I always say that 90% of the law, if it's a soup, of the ingredients in it is logic and common sense. And so anybody who, by the grace of God, is endowed with logic and common sense is 90% a lawyer. That's why they call you pocket lawyers. But let's move on. So that's the context.
Okay. I wanted you to proceed, move forward briefly on the non-executive, banter we have had.
I will come to it, but
and help us with your knowledge in that area quickly. Then we'll move on.
I'll make a bigger point that you see, in all of this, I think people need to step backwards and therefore give the people charged with the responsibility the space to be able to look into these things. And by the way, so who is Boulders? Boulders is then an investigator or auditor, financial analyst, retained by the central bank to look into these matters. They must have been, once clients hire you, they give you terms of reference and produce this report. So this report, if you want, could actually be looking one way. It's not looking at the totality of the circumstances that led to this, because all this hue and cry about liquidity support. Liquidity support, as your interrogations have led people to admit, are loans. These are loans that they give to you to help you, first of all, stabilize a crisis and recover. And in any event, unless you go down, you will pay. And some of the banks, up to the date that the plugs were pulled on them, were paying back to the central bank. But let's assume that when the dust is down, it's cleared, and we go through the process.
Sorry, just a second.
We find out that.
Just a second. Joe Jackson, is that the case that they were actually paying these?
I can't speak to that.
You can't speak to that. Okay, so it's a matter of fact.
It's only
so if it is the case,
central bank who can give us that information. I can't speak to that.
Yes, and so if it is the case, first of all, one is the case. At least we all agree that this is a loan which they must pay back. And if it is the case that they were paying back, either principal or principal plus interest, they were still going concerns. But let's assume that when we complete the process, we make the judgment that these assistance ought not to have been granted. Who gives support without first evaluating the situation? Because the central bank as regulator has unfettered access. Something they can knock on the door of the bank any day, walk into your vault, actually count your physical cash and compare it with what is on your closing balances. It's such an unfettered, wide power. So if it turns out that you ought not to have given this support in the circumstances in which you did. Do you blame the one who received the support, or you blame the one who gave the support in circumstances where they ought not to have given that support?
Give me a second again, sorry.
Who holds the trust to the Ghanaian people?
You, Mr. Jackson raised that, Dr. Tuahino also raised that question about the lack of appointment of a commissioner or a supervisor to monitor how the bailout money is used.
How your loan money is used.
Yeah, the loan money is used. Now, I want to understand, when they give out that money, is it that they just say, we have assessed that you need 600 million, so they just give it to you and you start using, or as and when you require it, they will vet the purpose for which you require it and actually be the ones to pay your creditors? Is that how it is?
So there isn't a one-size-fits-all. It depends on the circumstances. Typically, with overnight lending and some of these things, there are minor incidents where short-term liabilities are due. They suspect that their cash reserves is low at the bank. The Bank of Ghana can see it because they maintain these deposits on their behalf. They say, okay, you get this plug-in. My problem is that in this instance, it appeared as if the money was being injected as investment, in the sense that it looked as if these people have become chronically dependent on liquidity support.
And I'm asking that because they are giving the money, and as we told, they use it for a different purpose.
Well, because in one case, they went on using liquidity support for 2 years consistently, running the bank with it. And I'm saying there's nowhere in the world where central bank financing of day-to-day operations is considered acceptable. And I think he will validate that. So we have to be clear what it is. Every bank in Ghana, once in a while, gets some support from the Bank of Ghana, typically on very short-term basis.
All right.
In terms of the policy rate, the fact that the Bank of Ghana lends at the policy rate, but that is entirely the structure of the industry. You have a discount rate, you have a policy rate, you have a base rate. They all interconnect. That is the design. So the problem emerges when you have a moral hazard situation where it is quite clear to the person borrowing the money that I can rely on the central bank. I can rely on public money. Obtain a reasonable spread, because if you're getting a 10% spread, that is actually the average spread in the industry. So if you're going at 25% and lending at 35%, that is actually fairly close to the industry average.
Okay. Now, can you just finish up and quickly go to the questioning that you wanted to address also about non-executive and all that?
You see, because banking is central to a modern economy, and because trust and confidence is fundamental to banking, that is why these powers and arrangements are in place, that you can give support and bailouts, overnight lending, etc., because you don't want anything that dents the public confidence that your money is unsafe in a bank. In the last few months, what have we done? We are close to fracturing what underlies banking, which is confidence of the population in the banks, particularly banks that have indigenous Ghanaian ownership.
Okay, we'll find out what is happening about the implications. We can address that when
Bright is my time.
I will need to take a break. I need to take a break.
Because he's taking my time already once.
Yes, I need to take a break, and when we return, we can address this other aspect of it.
And I wanted you to speak to your directorship, because people have gone around with it, and there's just so much ado about nothing. Samson, this is section 203 of the Companies Act. Yeah, so I won't speak, I'll read it.
Okay.
Section 203 says, it's titled Duties of Directors. A director of a company stands in a fiduciary relationship towards the company and shall observe the utmost good faith towards the company in a transaction with it or on its behalf. 2, a director shall act at all times in what the director believes to be the best interest of the company as a whole, so as to preserve its assets, further its business, and promote the purposes for which it was formed, and in the manner that a faithful, diligent, careful, and ordinarily skillful director would act in the circumstances. 3, in considering whether a particular transaction or course of action is in the best interest of the company as a whole, a director may, in the interest of the, a director may consider the interests of the employees as well as the members are shareholders of the company, and when appointed by or as a representative of a special class of members, shareholders, employees, or creditors, may give special but not exclusive consideration to the interests of that class. For a provision, whether contained in the regulations of a company or in a contract or in a resolution of a company, shall not relieve a director from the duty to act in accordance with this section or relieve the director from a liability incurred as a result of the breach of a provision of this section.
Yes.
So this is the law on directorship. So all your additions, go and refine them, because people are making additions and subtractions. Now, when you are going to have to measure, and that's usually the problem, when the chips are down, this is the matrix against which the conduct, the actions, and omissions of the directors will be measured. Now, let's go to liability.
But there are subsidiary legislation in banking, yes, which are also relevant.
There is no subsidiary, there is no, if you want, and it's good you say subsidiary. If, and let me not be conclusive about it, if the Bank of Ghana issues governance directives or regulations, okay?
Subject to this.
Yes. Yeah. Pursuant to this. Those laws have a hierarchy. Just like everything in life has a hierarchy. The biggest law, the mother of all laws, is your constitution.
Indeed.
Under the constitution are acts of parliament. Under the acts of parliament are subsidiary legislation, pieces of legislation that other parliament may by law give other persons. So in this act, the director can issue directives which have the effect of law. Those are administrative directives. They don't override an act of a company. That's at least my sense of it. So all of those directives will not take precedence over what the company law says, because that's the primary legislation. Okay, are they relevant? Yes, because it's a subsector that is being regulated. But bottom line, you are appointed a director under the Companies Act, at the company's registry. But because it's specialized, the regulator then approves you because they will run you through what they call a fit and proper test.
But isn't it the case that you have more specific legislation in this case? So it should take, in some sense, precedence over the more general.
No, if you have a more specific legislation that runs pari passu, that is equal ranking, and one is general and one is specific, the specific will prevail.
Yeah,
but
so
first of all, you have to be talking at the same level, because of the hierarchy. At least that's my contention.
You are just reading liability. If you can just end on that.
So let's go to liability.
Yes, if you can do that
civil liability, section 209. And I'm not saying it. This is what the law says. The law says that where a director commits breach of duty under section 203 to 205. That's why I started by reading it to you, because this is the test whether the director is in breach or not. If the director commits a breach, A, a director and any other person who knowingly participated in the breach is liable to compensate the company for the loss it suffers as a result of the breach. Now let me pause. When you read law, lawyers, you look for operative words. So you must show, anytime you allege a breach of any of these duties I have read, that the director knowingly participated in the act that led to the breach. Otherwise, so please, let's calm down. B says, a director shall account to the company for a profit made by the director as a result of the breach. And C, a contract or any other transaction entered into between the director and the company in breach of that duty may be rescinded by the company. So this is civil liability. You are now going to go to criminal liability, and by the way, when you go there, the test is even higher, because in addition to knowing and acting and all of that, you then have to prove intent. You then so people should please. We should not put this appetite of calling to throw people. Let's deal with the important things. This is a regulatory failure. We need to go back and address the things that will enable us, develop, as the communication minister says, a robust, efficient, and well-functioning finance.
Thank you very much, Yonny. We'll take a break here. We'll return.